we're supposed to have 10 members. We only need 4 to form a quorum, but there are just 5 of us here. 3 would be adequate.
9個喎，而家佢都抌乜嘢？
我成日以為
你幫完咯。
我以為9個就係3個，10個係4個。
夠就唔好等啦，主席。等啦，跟翻規矩。
9啊，唔好等啊！
係啦，係啊，唔係你俾個原因我先點樣睇先？
根本好大晒，佢話唔好等，唔好等啦，係我哋。咁咪即係唔好話我哋建制。
If members suggest that we shouldn't wait when there is already a quorum, then I hope the Pan Democrats won't criticize the pro-establishment camp for having it their way. All right, I call to order the meeting of the Subcommittee on Dutiable Commodities LegCo regulations. First of all, let's elect the chairman. Members' nominations, please. A valid nomination has to be made verbally by a member, to be seconded by another member, and you should get the acceptance of the nominee and nominations, please. Mr. Yu Si-wing, Tommy Zhang. Mr. Stephen Ho, I second. You second. Then you're giving me great trouble. Are you going to accept it? I don't think I can disagree because I'm the panel chair of Food Safety and Environmental Hygiene. Do I hear any other nominations? I accept. Do I have to ask somebody else to chair the election? We're not qualified. Mr. Hong, yes, all of us are new. Members, are there any other nominations? No? All right, in this case, I declare that Mr. Tommy Zhang has been elected as the chairman of the Subcommittee on Dutiable Commodities Liquor Amendment Regulation 2015 and Dutiable Commodities Liquor Licenses Fees Amendment Regulation 2015. Thank you. Do you want to elect a deputy chairman? I suppose that this will be simple, and I hope you'll keep it that way. If you don't need to elect a deputy chairman, then let's go ahead with the discussion. First of all, meeting with the administration. So please invite the team from the administration to join us. We do have a few papers. We have file reference FHCR 2/3231/13. There's a LegCo Council brief issued by the Bureau. And we have also got the legal notice 20 and legal notice 21. We have also got a L.S. 35/14-15 paper, which is a Legal Services Division report. And then we have also got a paper CB-2 X63/14-15-03, which is a background brief prepared by our secretariat. And then we have also got paper CB-2 X63/14-15-02, which is a marked up copy. In attendance with the following public officers. We've seen him to March recently, and he is Mr. Christopher Wong, Deputy Secretary for Food and Health Food, Ms. Diane Wong, PAS for Food and Health, Ms. Vincy Chen, AS for Food and Health, Mr. Lee Kaki, AD Operations of the Food and Environmental Hygiene Department, Ms. Rita Young, Senior Superintendent Licensing from FEHD, and Ms. Cindy Chek, Senior Government Counsel, Acting Department of Justice. Mr. Wong. would you like to start off with any opening remarks? Thank you, Mr. Chairman. If I may briefly talk about the amendments in the subsidiary legislation. The purpose is to enhance the efficiency of liquor licensing. A few years back, in the year 2011, at that time we carried out a public consultation exercise. And then we have introduced a number of administrative measures to improve the licensing matters. In 2013, guidelines were issued by the LLB so as to set out the factors taken into account when issuing licenses so as to enhance the overall transparency. In the guidelines, we have made specific reference to the so-called upstairs bars. As a result of the special circumstances, we do have a very stringent vetting process. Under certain circumstances, we impose additional and more stringent licensing conditions. For the above-mentioned measures, they have already been launched and they are administrative in nature. However, in order to enhance the regulatory regime, we need to revise the law, and that's why we have presented the subsidiary legislation before you. First of all, the validity period of a liquor license. Currently, the maximum validity period is 1 year. We'd like to revise the regulation to extend it to 2 years so that the LLB will have more flexibility in dealing with non-contentious cases so that the efficiency can be enhanced and the LLB can spare time on the more controversial cases when they come up for renewal. As to the cases which would merit a maximum of 2 years validity period, we are mainly talking about cases with a good track record. Say, for example, 2 years immediately before the renewal, we haven't got any enforcement action and we haven't got any substantiated complaint. And then a full-term license was granted in the first instance. And thirdly, objection or adverse comments from the public haven't been received. We have tried to rely on the 3 points that I've mentioned to check the liquor license premises as at 31st of December 2013. And we understand that no less than 78% of such premises will be able to meet the requirements. In other words, they will be able to get a 2-year validity period for their liquor license. In the course of our consideration, we understood that certain district councils might have their own views, say for example for those districts with relatively more bars, and therefore when we put forward the proposal together with the LLB, we will set up a mid-term review mechanism. In other words, for licenses of a 2-year validity period, we won't wait until the expiry of the license before we check on it again. In fact, at the midterm, we're going to take a fresh look of the record of the licensee to see if there's anything we need to follow up. In this way, the relevant district council doesn't have to worry about the lack of sufficient consideration of local views expressed. Moreover, should there be any complaints, they will be acted upon immediately. As a result of changing the maximum validity period of a liquor license, there is an impact on the fees, and we are going to seek a amendment. Probably it will take time before we complete the comprehensive review of liquor license fees. For the time being, we would like to set the fee for license that is valid for more than 1 year at a level which is 1.5 times higher than the fee prescribed for a 1-year license. After we've completed the comprehensive review, we may come back with another proposal concerning the fees. And then there's one other area which requires amendment. We would like to provide for a more convenient way to allow for digital submission of the application. In other words, the LLB may assign or approve a password. In other words, the licensee or the applicant doesn't necessarily have to get a digital signature for the purpose of application, so it is technical in nature. Well, assuming that we have your endorsement, we plan to introduce the new mechanism on the 3rd of August 2015. In other words, licenses issued on that day and thereafter, they may have a validity period of up to 2 years. We do need such a long lead time because we need to give time to the licensee to make preparation. Therefore, the new regime will come into effect on the 3rd of August. I'm happy to take questions from you. Members, if I may seek your advice, do you think we need to carry out a public hearing? Stephen Ho, you would like to have one? I think we can set aside time to discuss that idea. Mr. Sin Chung Kai, 5 minutes each in the first round. Thank you, Mr. Chairman. According to what the DS has said, I think 70% or so of the licenses are not contentious. But then if you make a change and grant the liquor licenses for 2 years across the board, then for the contested cases, of course, as you have said, if it is not contested, then the liquor license can be granted for 2 years. But then I want to know if it is subject to JR, or will you write into the or provide in the regulation that whenever it is a contentious case, then it will not be given 2 years as the validity period? Or can we have 2 categories of licenses? For category A, the validity period will at most be 1 year, and then for category B, you are satisfied with the good track record, and then the validity period will be extended to 2 years or even 3 years. Or you may get downgraded if you get a 2-year license and then your record is not good, and then you get a 1-year license after that. What about granting a license good for 1 year and 9 months? If you say that because of the complaints, the license would not be for 2 years, but then it will still be longer than 1 year. So sometimes the public have complained that you are being too lenient in granting the licenses.
Mr. Wang, the first question was about the appeal mechanism. After decision is made by LLB, there is an appeals mechanism in place. And on the period of the liquor license being granted, in some cases under the current system, the LLB would not grant a full-term license of 1 year. If necessary, the LLB might grant a shorter license, say 6 months to premises. in order to address the public's concerns, other than the liquor license, there are other things we can do. For instance, restricting the operating hours of liquor selling premises, or we can also ask them to close before 12 midnight. And we can also ask them to install noise barriers and so on. So we do have a number of approaches and things we can do to address the public's concerns. The validity period of the liquor license is only one of the things we can do. And we already have a system in place for a number of years now to receive the public's comments or views. And it has proved rather effective in dealing with the views of the various districts. So our current recommendation has struck a balance between the interests of different people. You did not address my question. You said if you receive complaints, you will not grant a full 2-year license. It's not written in the law. It's only written in the paper. If the LB receives complaints, there's nothing they can do. If a 2-year license has been granted, as I mentioned, there is an appeals mechanism. You said if there are complaints, a 2-year license won't be granted, but that's not the case because this is not written in the legislation. Under the relevant provisions, the LB has a statutory function. It has to consider public interests. The design of the law is such that the LB will have the flexibility to consider various factors before coming to a decision. Of course, the views of the public is one of the areas they must consider. I'd like to add something. I've been on liquor licensing board for quite some time. The provisions actually provide LB with a lot of leeway and privileges, and the validity period of the liquor license being granted can range between 1 and 2 years. Some people complain for the sake of it simply because they don't want anyone to sell liquor nearby. In such cases, the premises can seek an appeal, and even if they lose the appeal, they can seek judicial review, and so these are two further steps they can take. Mr. Ray Chen, I have a question on the fee of the liquor license. The government is always talking about cost recovery, and just now the Deputy Secretary said the fees will not be reviewed. So my question is, why didn't you review it if you have to adjust the fee, if you know you have to adjust the fee? And my other question is about the validity period of the liquor license. According to the paper, premises with 2 years of continuous good performance will be more likely to have their licenses being extended by 2 years. So I just want to know what it's meant by a good track record. Is it related to the noise or the environment and so on? if they have any, if there are any blemishes in their records, will they be considered for renewal? Do they have to be absolutely perfect and receive no complaints whatsoever? Or will you assess the continuous performance during that period? Mr. Wang. I'll first address the question on the validity period of the liquor license. And by a good track record, we will look at premises with at least 2 consecutive years of good performance without substantiated complaints or violations. And for the previous term, the premises must have obtained a full-term license. And for all liquor license renewal applications, the public will have a chance to raise objections. And the premises must not have received any objections or complaints. And for premises with a good track record, the LB will be likely to grant a full 2-year license. And if negative views are received, the LB will consider whether or not to grant a less than full-term license or impose additional licensing conditions. That's the final decision of the LB. If the record of the premises is unblemished, when we look at the records at the end of 2012 or 2013, and we are confident that 78% of the premises can obtain a full-term license. So at the end of the day, the LB has a final say, but we expect at a minimum of 78% of premises being granted a full license. So maybe I'll ask my teammate to give more on the fees. By substantiated complaints, we refer to cases in which the premises has been prosecuted or received any written or verbal warnings, and only in these cases would the complaints be considered substantiated. According to our timetable, we will come back to the panel at the end of the year. We have some initial figures, but they must be circulated internally before being announced. According to these initial figures, we have not achieved full cost recovery. So what's the percentage? Well, what's the cost recovery ratio? 50 to 60%. Yeah, that's it's around that range. 60%? No, it's around 50 to 60% at the moment. I think just like food licenses and public market licenses, we have not increased the liquor license fees for 18 years. So you cannot expect full cost recovery. So are they going to raise the fees again very soon? Well, it won't be of any surprise. I'm referring to the review mechanism. Recently, the government said they want to increase the fees for cremation. Mr. Yu Si-wing. You said that 78% of the premises have good track records. If we extend the validity period of the liquor license to a maximum of 2 years, will really benefit the trades. So at the moment, I support this extension. some people from the trade told me that the standards for granting liquor licenses seem to be different. For bars, the licensing process seems to be more stringent than, say, restaurants. And when the amendment regulation is in force, in terms of inspections and the imposing of conditions, will there be any differences? Or will the same standards be applied to all kinds of premises? And my second question is that after granting a 12-month license, there's a possibility that the performance of the premises be deteriorated. And you mentioned a midterm review might be done after 11 months. So why is it done after 11 months and not 12 or at any other time within the period? And what is the probation period for new licenses? Is there a probation period, or would all of them be granted 2 years? The first question was about the bars, and apparently they face more stringent conditions. For upstairs cafes or upstairs bars, it's relatively more difficult to enforce the conditions, and as such, the authorities are usually more stringent with these premises. As I mentioned earlier, the LB issued a set of written guidelines to elaborate on the factors they consider when they vet the liquor license applications. And the reason we conduct a midterm review at 11 months, well, I agree with you that if the licensee breaches any liquor license condition, for serious cases, the LB can suspend the license. And if there are no serious breach of conditions, at 24 months, our teammates will vet the application again and consider whether the case needs to be assessed by the LB again. For new licenses, the validity periods might be shorter. When the LB would consider whether the licensee is a fit and proper person, and they will also check the past records of the premises. In some cases, they might grant a less than full-term license. So it really depends on the specific premises. And after some time, with a good track record, the premises might be able to secure a full-term license at the next renewal. Well, I have a question for Ms. Young as well. For bar endorsements, would bars be given the same treatment as restaurants when they try to apply for a liquor license?
Yes, just go ahead. If I may try to answer the question. Sometimes there may be extra endorsements for a new liquor license application. Say, for example, bar endorsement for premises usually called bars. Generally speaking, at the time of application, we'll refer the application to other departments for advice. The HAD will send out the local people. The police will also be asked to comment on whether the applicant is a fit and proper person. The police will interview the applicant. The mode of operation will also be a matter of inquiry. For a bar, it means that the sale of liquor would be the core business. This is different from general restaurants. For general restaurants, the sale of liquor is to accompany the sale of food. So if it is defined as a bar by the police, and if the applicant asks for a bar endorsement, then in the light of the mode of operation, the police may ask the LLB to impose additional liquor licensing conditions. Say, for example, closing the doors and windows after a particular time, and should there be sound equipment, the volume has to be lowered, or there may be restrictions on the liquor selling hours. So bars and restaurants may have different licensing conditions depending on the mode of operation and the police advice. The LLB will consider such matters. I'd like to pursue this line again later on. Next, Mr. Stephen Ho. 78% and 22% being the split. Administration, can you clarify this point? Now, currently, at the local level, it is worried that if you allow the validity period to be up to 2 years, then it is worried that the neighbors will be affected. So how are you going to conduct the local consultation? Now, the citizens are smart, but then they may not have sufficient time, so they have reservation. How are you going to conduct the consultation? Now, we may be talking about a general restaurant, and then they mainly sell roasted duck, and then they have the sale of beer, but then that would be different from the running of a bar. And then another question is about the dollar sign. It may not directly related to the regulation before us. Now, if the maximum validity period is for 1 year, then it will cost you $3,940. For 2 years, $5,910. But then it could be a less than full-term license. Do they still have to pay $3,940? It will be proportional to the validity period. In the bylaw, you have the fee scale. Mr. Wong, I try to assist. It is said that about 18% of them have not been the subject matter of complaints. Among them, have we got any bars, or are they all just Chinese restaurants or Hong Kong-style cafes? If you haven't got the figures with you, it doesn't matter. You can come back, because we do plan to meet with the public. There will be a public hearing. So why don't you go back and get the figures and tell us next time? Sure, Mr. Chairman, we'll be happy to provide the data. And please also tell us about the distribution of the complaints by district. To answer Mr. Ho's question, well, we're going to follow the same practice. Upon renewal, the applicant must inform the public by placing an advertisement. If there is an objection, or should there be adverse comments, then the LLB may impose certain conditions if it is felt appropriate. It can also be in the form of a less than full-term license. The LLB has got discretionary powers depending on the merits of the case. Mr. Ho, you don't need to worry. The renewal process does have an element of receiving input from the public. And the LLB has also got the arrangement to hold a hearing. And the mechanism has been in place for quite some time. When we prepared the proposals before you, we did consult those district councils which have got relatively more bars and licensed premises. Some members shared your view. That is, some premises might have got longer than desired length of time for the validity period. And it is also worried that a longer validity period may mean that the public can't do anything about a bar or an establishment which has seen the performance worsening. That's why we have come up with the idea of having a midterm review to make sure that if it is found that the record of performance has deteriorated, then we will go back to the LLB to see if the board has to handle the case. So we believe that such an arrangement can, to a very large extent, take care of the worries of individual district council members. Any follow-up later on? Mr. Wong Ting Kwong. Thank you, Mr. Chairman. I believe that for applicants for a liquor license would include bars, restaurants, clubs, Chinese restaurants as well. Now you have to seek a renewal annually. If the validity period is to be extended to 2 years, it will facilitate the operation of businesses. It can spare them the trouble. But then I have one observation. For the local people, for the neighbors of the licensed premises, usually they have got certain negative comments of bars. This is mainly because of the different mode of operation. For Chinese restaurants and clubs, their clients are more restrained in the consumption of liquor. But then for bars, probably the clients may have a different attitude when it comes to the consumption of liquor, and as a result, they may generate a lot of noise. They may even resort to a fight. While we want to facilitate businesses, while we streamline the procedures, we mustn't forget the problems. Just now, some colleagues have also mentioned the idea of having a two-tier system, Cat A licenses and Cat B licenses, so that while one group of premises like bars will get 1 year only, for the rest, Chinese restaurants, clubs, etc., they get up to 2 years. But of course, if they are generating complaints, then they will have their status downgraded so that they get a 1 year license only. Would it be possible? I think if the department is to adopt such an approach, I'm sure you will meet with less resistance at the district level. Now, for the fees for a 2-year license, I understand that it is planned to be pitched at 1.5 times the fees for a 1-year license. At the same time, we've been told that we're supposed to follow the user pays principle, but so far you've only recovered 50 to 60% of the cost. So there is a problem here. Right after revising the fees as part of this exercise, you may soon have to ask for another fee increase. Why don't you just increase it to 2 times in one go, and that can save us the trouble? I'm not supposed to make such a comment since I am responsible for this constituency. I think it is out of proportion. You are not doubling the amount of fees for a 2-year license because you suggest that it should be 1.5 times. I don't think you are increasing the burden of the licensees because by getting a 2-year liquor license, one will save in terms of time and administrative work. Bearing in mind that you have told us that you haven't recovered the full cost, so I think the message that you sent out would not be good. I think there is an incentive because they can really save on the operation cost, but they can also save on the manpower, but you're only recovering 50 to 60% of the cost. Well, I think the Secretariat will have less workload if they get 2-year licenses. Well, as to whether we can have a 2-tier system, but then to be fair, if individual licensed premises can have a good track record for 2 consecutive years, then I don't think we should classify them on the nature of their business and have 1 year only across the board. I think the emphasis is on a good track record. When that is satisfied, the board can exercise discretion and grant a 2-year license. For the fees, 1.5 times. This is transitional. The chair is right to say that we are providing an incentive. Towards the end of the year, we are going to take a comprehensive view on the liquor license fees. We will act towards full recovery of costs. Personally, I believe that I think we can look at the matter objectively. If we can easily process a license application, then in accordance with the user pays principle, then the fees should be lower than what we are charging currently. But of course, we can have further discussion in the future. I just want to say that I fully appreciate what the member has said, and we have to be fair towards the trade. That's the principle that we uphold when we discharge our duty. Now, when we grant a 2-year license, I don't think. I think if the process is simpler, then proportionately speaking, probably the fees to be charged as a result of the lower cost should be lower. Now, even for a 12-month license, it will be simple. You are not going to make life difficult for them. No. They have to go through the process. A 1-year license and a 2-year license will have the same sort of process. I think you have taken the wrong seat, Chair. Why don't I chair the meeting for you? I think it is already a very big incentive to get a 2-year license. It isn't just a matter of money. Of course, the trade would welcome a 2-year license, but then while I'm acting in the capacity as a lawmaker, I have to point this out. You should have increased the fees in proportion to the validity period.
So this is something the government can consider. It seems we have some differences in views, Chairman. Your compatriot has been criticizing me. Dr. K.K. Kwok, you should be in honeymoon. Why are you still here? It's time for you to ask question. Thank you, Chairman. The government's response is not satisfactory. And for those who want to apply for a liquor license, the maximum validity period is extended to 2 years. It seems that they can save a year, and apparently they only have to pay 1.5 times of the fee, and in effect they have saved some money. If you get your math right, if you are able to recover full costs, then it makes sense. But from what you said, you haven't done the calculation, so I'm not sure how much you can save at the end. Without concrete figures, we cannot agree to the amendment. If you manage to save money to benefit the trade, then it makes sense. But without such justification, it's hard to convince us. So I think you have to come up with the right figures. In the past, we have seen cases in which there were objections from the districts, but yet the applications were approved by LB. You said you would introduce a midterm review mechanism for licenses of a 2-year validity period. After such review, since the validity period of the licenses is 2 years, even if problems are detected, you will only issue warnings or notices, and their licenses will still not be suspended. And as such, if there's, in case of any problems, the public and residents will still suffer. When you receive complaints, substantiated complaints, are you going to suspend the liquor licenses? Is this what you're going to do? If you renewed licenses on a year-to-year basis, then it's easier to tackle these problems. But for 2-year licenses, will you only issue warnings and notices in case of complaints? Under the existing mechanism, we have dealt with objections from the community. Even with 24-month licenses, well, in fact, regardless of the validity period of the licenses, if the licensee is in serious breach of licensing conditions, for instance, if any criminal activities are detected in the premises, for example, the provision of drugs, according to the police recommendation, we can suspend the license immediately. We wouldn't have to wait until the 12-month or 24 months period is up. So if slight breaches are found during the midterm review mechanism or the midterm review, then we will, the LB will look at that. If there are slight violations, the LB might consider reminding the premises of the problematic situation. And if these slight problems are substantiated, it would affect the applicant's chances at the next renewal. For full terms, we stress that the premises must have a good track record, even if they have slight problems or complaints. Their renewal in the future might be affected. Thank you, Chairman. How about the estimates on cost recovery? I don't think they have the figure today. As I mentioned, with time, by the end of the year, the figures might be updated. However, we do have initial figures for 2-year licenses. The fee is 1.5 times. The cost recovery level is close to 100%. I don't think she understands my question. Going from 1 year to 2 years, how much can you save? The existing fee is 3,900, and the new fee would be, and for 2 years it's about 8,000. But for 2 years, under the new proposal, the applicant only has to pay about 5,900, and so actually the applicant can save some money. I hope you can go back and look at the figures. For applicants without any complaint records, the renewal process is rather straightforward. Whenever a renewal application is filed, the Secretariat at LLB has to do a lot of things. It has, for instance, the application must be published by Gazette and so on. I think you have to really look at the cost, the total costs. And if the maximum validity period is extended to 2 years, with the extra 50% in fees, then you might be able to achieve full recovery of costs. Dr. Kenneth Chen, I'd like to invite the government to look at Annex F. Annex F lists out the financial implications. With the new proposal, the Treasury will receive 2.7 million less in revenue. So can you elaborate on that paragraph, on the second paragraph? Of course, you will submit figures to members later. But is it the case that the Treasury will receive less revenue in the future? Mr. Wang. Annex F, paragraph 2. Perhaps we will provide the figures in writing later on. Sure. Can you do that before the next meeting? They can provide a breakdown of the figures. Dr. Chen, the decrease in revenue is really just like what I said. And when the validity period of the license is extended to 2 years, they might actually get more. Well, perhaps we can wait until the next meeting. And the denominator has changed when we extend the validity period from 1 to 2 years. So we are really talking about different denominators. So perhaps our teammates at the financial team can give a better elaboration on that. I want to stress that cost recovery is still our principle. Can you illustrate this principle with further information? And another area of concern well, it's something non-LB members and the general public want to know. Since the LB is so powerful, and as you mentioned, more than 78% of the applications are uncontested, you can consider streamlining the application process. Well, you can suggest you can consider streamlining process instead of moving these amendments. Have you considered this possibility instead of making it so complicated, Mr. Wang? Some liquor selling license premises are rather uncontested, and I think it's very hard to streamline the process just for these uncontested applications or premises. Even premises with a good track record can be contested at some points in the future. So it's very hard to define any premises as absolutely unblemished. You mentioned premises with 2 years of continuous or consecutive good performance. Well, based on common knowledge, we understand it as premises without any problems or complaints. Since these won't be covered under the amendments, I think the LB can apply the same set of standards when they consider the renewals. You said you want to give the LB more time to tackle the contested applications. If you can deal with uncontested cases with internal guidelines, then you can focus your energies on contested ones. That's the way the LB works. But under the new proposal, they would have the leeway to grant longer licenses. And as such, they can save time with more straightforward and uncontested applications. For contested cases, they have to spend time. Nonetheless, that will not change. But in the future, for premises with good track records, the LB can streamline the process, and they can focus their time on contested applications. So this is the thinking behind the entire set of amendments. I think I understand that introducing or extending the maximum period to 2 years serves to strike a new balance. For contested cases, the LB has to do something nonetheless. If they receive complaints, they must do something. When they receive complaints from the public or even the police, they have to hold meetings. Ms. Young, I'd like to add something. When the LB deals with contested and uncontested applications, well, usually premises with good track records are uncontested. These cases won't have to be referred to the relevant departments, for example, the Home Affairs Bureau and the police. So the process is relatively straightforward for premises, liquor selling premises with bad track records. When they apply for renewal, there would be usually be objections from the public or district personnel, and in such cases, the LB will usually consult the district councils or the police for their advice. Sometimes additional licensing conditions would be recommended, so the process is more complicated. Premises with good track records will be given 2-year licenses, and there's relatively little chance that these applications will be contested. And for premises with shorter term licenses, other departments would have to be consulted by LB, and the process is rather long. And the costs would also be different. Dr. Chan's question was that if you don't amend the regulations, is there nothing the LB can do? Under the existing law, the maximum validity period of the license being granted is only 1 year. And through these amendments, we can grant 2-year licenses for premises with good records. And as such, the number of renewals will drop, and we can the LB will have more resources and time to vet contested applications. Chairman, I think you misunderstood what I meant. I understand that under the existing legislation, we cannot grant licenses more than 1 year, but my question was about cost effectiveness and the decision-making process. If the amendments can bring convenience to the LB and the trade, can you make sure that you can fully recover the costs and perhaps charge more than 1.5 times the existing fee? I'm sure the trade has been expecting these amendments for a long time, especially the electronic submissions. I think this is something the trade is looking forward to. I think you're working on the same change for food licenses, right? For both liquor licenses and food licenses, electronic submissions will be accepted. What are the differences between both? Since the liquor license licensee has to sign on the form, if they submit their applications electronically, they must use a digital signature.
We launched this mechanism in August 2010. Towards the end of last year, about 280 applicants tried to lodge an electronic submission, but then they might not have a digital signature certificate, and therefore they were not able to submit successfully. And there were only 4 successful electronic submissions. From this, we find out that as a result of the absence of a digital signature certificate, they're not able to do so. And in order to facilitate electronic submission, we're now saying that other than the digital signatures, we should provide an alternative route. That is, the LB may assign a prescribed password to verify the identity of the applicant. So we are sort of providing a choice to the applicants so that in addition to digital signatures, they may also make use of a prescribed password. I think that they can still submit a written application form. Yes. I have one other worry, which is shared by the trade. Absence of the licensee. I have left the LLB for quite a period of time. I'm interested in the duty hours of the licensee. Paragraphs 16 and 17 seek to amend Regulation 24. we do allow a licensee to be absent. He may appoint a person to stand in his place at most for 3 months. Yes, I do understand Regulation 24. But then having read your paper, now I'm not talking about the period of absence, rather the duty hours. I'm worried that sometimes a eatery may open for 16 hours a day and they sell liquor. I don't think you expect a person to be on duty throughout those 16 hours, and you check his presence by carrying out police visits. Of course, sometimes we may impose a licensing condition to specify the duty hours of the licensee to cover the busiest hours of the operation. Say, for example, for 6 hours out of the business hours, the licensee must be present, and he's supposed to take his lunch or meals on the premises as well. We don't expect him to be present throughout 16 hours. When the police come and find that the licensee is absent, so are you saying that if his absence doesn't exceed a particular percentage, then he will be fined? Otherwise, his 2-year liquor license will be revoked or amended? I want to say that for Regulation 24, it is about absence rather than his duty hours. Well, for the duty hours, the applicant will have already set out his weekly day off as well as his duty hours on a daily basis in the application form. And in fact, this will be referred to the police. In other words, the police will be made aware of such information. For the routine check, if it so happens that the licensee is having his weekly regular day off, or the police come outside his duty hours, this will be known to the police. Now, for Regulation 24, that's about being absent for a longer period of time owing to illness or taking his annual leave for holidaying, etc. He may want to be absent for 7 days or 14 days in the form of his annual leave. Then Regulation 24 will cover such absence. Currently, it is said that it should not exceed 3 months in the context of a 1-year license. In the future, we're going to have a 2-year license, and that means that the validity period is longer, and we believe that we have to adjust the permissible absence period accordingly. 3 months for a 12-month license, and that means 1/4 of the total period, and therefore we are adopting 25% as the basis for granting leave of absence. That's for being ill or otherwise absent. Mr. Yu. Mr. Chairman, I've read the guidelines on assessing liquor license applications. So paragraph A is easy to understand. The applicant is a fit and proper person. Paragraph B, the location and structure of the premises and the fire safety and hygienic conditions on the premises. And C, not contrary to the public interest. All the 3 factors will be applicable for new application as well as renewal, right, as well as upstairs bars as well. So you will check the personality of the licensee or the applicant, and you'll pay visits, right? I want to know whether you have consistent practices. I've heard from the trade that it is not consistent. Sometimes certain inspectors will be more lenient, and then the duration also varies. Now, of course, the premises are different one from another. I want to know whether you have clear guidelines internally for different officers within the department to follow. And then I want to know about the definition for objection or adverse comments. When there is a new application, the residents of the same building may object. It can be done in writing or verbally, or a district council member may organize a protest by taking to the street. So do you think that an objection can simply take the form of a written complaint, or do you have certain criteria before you are happy that there is an objection? Well, the vetting will be carried out by the LLB, so the criteria, the standards are consistent. We have the same members within the same term. Now, for the guidelines and the criteria therein, they won't change with the changes of membership. Now, the validity period may vary, and there may be different licensing conditions. This is all because the LLB would consider whether the applicant is a fit and proper person, whether the premises are suitable, and whether it is in line with public interest. The district office will carry out a consultation exercise. There may be some objection from the local people. Now, they may think that the venue is fine, the location is fine, but they don't want the liquor selling hours to be so long. So a license may be granted, but then, as mentioned before, the validity period may be shorter so as to monitor the performance, or in the light of the police advice or local opinion, certain licensing conditions may be imposed, which can take a number of forms. Say, for example, by 11 or by 12, the sale of liquor should stop, or in the light of the vicinity or proximity to the residence, doors and windows may be closed after a certain hour, or music should not be played. So there may be corresponding liquor licensing conditions. Objection as referred to in paragraph 12. We don't mandate it to be in writing. Anybody, any resident or citizen may express their opinion. In the year 2012, on the website of the LLB, there is already a place where the citizens can voice their objection. The FHD, the EPD, the police are also channels to receive complaints. In fact, the LLB can be reached by means of telephone calls or emails. Can I have another follow-up? Yes, please. Now, we know that when you want to operate a bar or a restaurant, you will renovate the place. You wait for a license, and then without a license, you can't commence your business. Do you impose a time limit so that the operator knows for how long they have to wait? Otherwise, they have to pay the rental and pay the wages while waiting for a license to start the business. So do you have a time limit to finish the processing so that the applicants will be kept in the picture?
For new liquor license applications, if all goes according to plan, the LB will need 8 to 10 weeks before it's approved. But as I mentioned, some liquor license applications involve public interest, and as such, consultation has to be done. For instance, publishing by Gazette and consulting the Home Affairs Bureau. If any objections are received, the ALB might decide to hold an open hearing to hear the views of the public and the applicant. And under such circumstances, if any open hearings are involved, the length of time for processing will be longer. And the ALB must wait until they receive all the comments from objectors. And after these are dealt with, then another 8 to 10 weeks will be required. What about the procedure? After receiving the applications, the ALB must consult the relevant departments and see whether there are any objections before they decide whether or not an open hearing will be held. So they cannot say for sure when they receive the applications. In normal cases, only 8 to 10 weeks will be required if there are no objections. I suggest that once you receive an application, you should list out the basic conditions, and if these conditions are met, then I can grant you a license within 10 weeks. This will make things clearer for everyone. In case of objections, you can tell the applicant that, let's say, perhaps you are in breach of the second licensing condition, and so at least the applicant knows what's going on. Ms. Young, does the ALB have any service commitments on its website? The time frame of 8 to 10 weeks has already been mentioned on the website. If open hearings are involved, the time will be longer. From your experience, between the time of a public hearing to the time of granting a license, how long would it take? It really depends on the case. If all the requirements are met and all the documents are submitted, most premises will also apply for food licenses. And the service commitment by FEHD is 5 working days, provided that a liquor license has been granted. If all the information and documents are ready, only 5 working days are needed. If there are objections, will the FEHD decide to hold any public hearings? If a resident raises an objection and if he's willing to disclose his or her identity, the LB will decide to hold a public hearing. Unfortunately, what you said doesn't seem to be the case. If the objector refuses to show up at the public hearing, then their case won't be tackled. And in recent terms of the LB, public hearings will still be held for anonymous complaints and objectors who refuse to show up. You should ask the bars you know to send representatives. There's a common misunderstanding within the trade that a liquor license can be granted together with the food license. They have some misunderstanding on the timing. They thought they could be these 2 licenses can be granted together. in the past, a lot of premises sold liquor without a license. But if public hearings are involved, there are usually some hiccups to the applicants. So I think they should be, you should allow them to apply for both licenses at the same time. According to past practice, if anonymous complaints would not be tackled, but if you receive anonymous letters with similar comments, then I think you have to think about it. So I think you should make it clear in the law. The problem is that the ALB is very powerful, and they can decide their own standards. Since some members may leave, and I seek the subcommittee's support for moving a motion at the council meeting on the 25th of February 2015 to extend the scrutiny period to 25th of March. I'm afraid some members will leave and we won't have a quorum anymore. Dr. K.K. Kwok. Thank you, Chairman. I talked about the cost recovery in the first round, and in the second round, I asked about the process of the progress of processing the cases. The administration said the processing time is 8 to 10 weeks. It's not very long and it's not very short either. And if the maximum validity period is extended, in theory, the workload of the LB will be lighter. So as such, can they speed up their approvals? The LB operates on public money. If you can streamline your approval process, it's a sign of efficiency. Right now, you said you need 8 to 10 weeks. Is this really a normal processing time, or is it because you are already very busy and you have lots of cases in hand, and as such, you need 8 to 10 weeks? Can this be further compressed? 8 to 10 weeks refer to new applications for license renewals for premises with good track records. Without contested cases, the processing time can be shorter. For uncompleted applications, well, in theory, the ALB would convene a meeting every week. If they have a lot of caseloads, they would have more meetings, and as such, not a lot of applications will be left undealt with. Will the new arrangement help shorten the time for new applications? With the maximum validity period extended, the workload should, in theory, be lighter. So you can save time and money, right? I'm sure everyone will agree with the proposal. Well, I think it makes no difference to the LLB. I think it helps the Secretariat more than the LLB, because the LLB has to deal with contested cases nonetheless, and they have to deal with objections from the trade. If there are new arrangements which can decrease the number of meetings they have to make, they would welcome it for sure. For the thousands of licenses have to be renewed every year, and letters have to be sent. And my second question was, since I've never been on LB, unlike the chairman, on the periods or provisions on temporary absence on the licensee, would you check their timesheets to see whether the licensee is absent from the premises for a specific length of time in a year, or are you going to do periodic checks and see whether or not the licensee is present or not during those checks? Well, I asked a similar question. The amendment deals with the time on leave for the licensee. So you're asking the licensee to report to the LB if they are taking a leave or if they fall sick, something like that. Well, every month or so, the police will conduct checks. If they do not see the licensee, they would note it in the report, and it will be shown up during the license renewal. Let's say they conducted 15 checks and the licensee was never present, and as such, they would question whether the licensee is a fit and proper person. Well, perhaps Ms. Young can answer this question now that Mr. Sin Chung Kai has left. You are very right. The workload of the Secretariat will be decreased. For simple cases, the LB does not have to convene meetings behind closed doors. And for the second point, the authorized manager refers to someone who helps manage the premises in case the license holder is absent temporarily. And the police will be the enforcement unit, and they will conduct checks and inspections. And they will look at the records of the premises before deciding on the frequencies of the checks. There are a lot of cases in which the applicant it's always absent. We don't have such figures. Well, I can tell you that there is no such record. But if the police makes frequent checks to a premises because of complaints, and if the police doesn't see the licensee, they will request for the duty hours of the licensee from the LLB. For instance, 12 a.m. to 4 a.m. Of course, no one will expect the licensee to be here for almost 20 years, but at least the police must know the hours of work for the licensee. And if during his duty hours the licensee is absent, then the premises will face trouble during the next license renewal because the police might deem the applicant not a fit and proper person. If they cannot switch to another licensee, then in all likelihood the premises will not be able to obtain a liquor license renewal. They don't have such statistics, but I don't think this is a big problem because in such cases the LB will impose additional licensing conditions. Well, in the past, when the police makes checks and the licensee is not here, they would note it on record. Well, my suggestion was to provide 15 minutes for the licensee to return. If he or she doesn't return within 15 minutes, it means he's not here. Well, I think this will help smooth out some conflicts between the LLB and the applicants. Well, because sometimes the licensee or the licensee is only having lunch nearby, and he can come back when called upon. Next, the clause-by-clause examination. Mr. Wang or Ms. Young, in Annex A, it's about the Dutiable Commodities LegCo Amendment Regulation 2015. Annex B is about the fees. So we have two parts here. So perhaps we'll look at Annex A first. First is the commencement date. As the Deputy Secretary said, if the subsidiary legislation is passed on the 25th of March, the FEHD will send invitations to applicants who need to make renewals. And the regulation will come into operation on the 3rd of August 2015. And I think you are all aware of that.
Clause 2, amendment to the Dutiable Commodities LegCo regulations. We seek to amend the regulations as set out in sections 3 to 6. Section 3, Regulation 20 to be amended. If you may want to turn to the marked up copy. Prescribed fee or such proportion thereof as provided by paragraphs 4 and 5 that is to be repealed. And we say that for a 1-year liquor license, now in Annex B, we're going to cover the fees, and the legal advice is that in Cap 109, we are going to remove this reference. What about the fee for a 12-month license? It will be proportional. We are not going to change the formula. The only difference is that the provision will now be accommodated in the fees regulation. Mr. Yu, I just want to find out where we are at. You are too quick for me. CB bracket 2 8663/14 to 15 bracket 02. Have you got it? Just a moment, please. Annex A, I don't think I have it. An annex to the LegCo brief. I haven't got an annex to my paper. You may want to read the marked up copy. Yes, I've got it. For the marked up copy, for 4 and 5, that's about the formula. In the case of a license granted for a period other than 1 year, the fee payable will be proportional. And then it also sets out the scenario in which it is less than $1. So we're going to remove it and have it housed under Cap 109, subsidiary legislation H. 3.2, repealing 1 year to be substituted by 2 years, or a period which is shorter than that but deemed to be appropriate in the eyes of the LLB. 3.3, repealing paragraph 4. 3.4, repealing paragraph 5. As we have already said, they will be housed in subsidiary legislation H. Subsection 4. We are going to substitute Regulation 24. In the case of absence or illness, how are we going to deal with the requirement on the licensee? We're repealing the original Regulation 24, and then would like to set out the new requirements. Now, since a license may be longer than 1 year, so maybe the licensee will be absent for more than once. We already had a provision to say that the aggregate amount will not exceed 3 months. Now we make it clearer. It can be on more than one occasion, and then the aggregate of the periods will not exceed 25% of the number of days of the validity period of the license. So 2 years, it means that you can't exceed 6 months, which is 25%. For 24(1), that you're now going to repeal. Now, in the future, you can have electronic submission, but in your draft, it is to be in writing only. So I want to know whether you have to do it in writing in the case for application for absence. You are correct. When you want to seek out a liquor license or renewal, then you submit the application to the liquor licensing board. Now, in the case of illness or absence of licensee, you apply to the secretariat. Why can't you align them? Now, new application or renewal are matters of great significance, and you permit electronic submission. Here, the leave for absence maybe for a week or 2. How come that you don't allow for electronic submission? Well, we have to consider the fact that other than the licensee himself, the authorized manager may also fill out some information, and the police may have to interview the authorized person. I think this can be reviewed, but at this stage, well, in fact, this is permissible. Sorry, I've got it wrong. Please take a look of 24(1). Well, if you read the marked up copy, it only says in writing. Please turn to 26C. Yes, the legal advisor has told me that this is permissible. Regulation 24, I've covered this. Next, I turn to electronic submission and the assigned password. In Section 5, we are going to add Regulation 26C, and this is about the electronic submission of applications. In accordance with 15(1), 24(1), 24(1) is in relation to illness, or 26(2), a person may resort to digital submission, and he may also use an assigned password to replace the digital signature. In this way, the applicant may choose electronic submission. Next, we move on to Section 6, which means we are going to add Regulation 34 after Regulation 33 to provide for transitional provisions. Well, we want the regulation to come into effect on the 3rd of August, so we've set out the different scenarios to set out about the applicability in relation to the applications submitted on different days. If you're happy with Annex A, I suggest that we go on to Annex B. Members, any questions for Annex A? No? Then we move on to Annex B. We seek to amend Cap 109 sub-leg H. That's about the fees. Currently, we have set out the fees in 109H, and then Section 1 commencement. Same as the previous one, we expect it to come into operation on 3rd of August 2015, and we want to amend Sections 3, 4, and 5. Section 3, would like to add 1A before Section 2, which is interpretation. In other words, liquor license will have the same meaning as that in Cap 1 through 9B. Section 4 is about the fees. I've already explained previously in Cap 1 through 9B, we would like to provide for a provider license fee for licenses less than full term, but would like to have it provided for under 1 through 9H. And then Section 5, the schedule is to be amended. First of all, a change of the punctuation. And then, if the license is valid for 1 year, we have a specific fee, and then if it is for more than 1 year, there's also another figure, and we are simply setting out the figures already given in the LegCo brief. That's all the amendments we are seeking. Thank you. All right, members, any questions? If not, I think we can try to find a date to receive deputations. I've got 2 dates available. February 26th. Sorry. Would it be too rushed? 10 days, but of course we have the public holidays in between, and that's the 7th or the 8th day of the Chinese New Year. And with the budget, I don't hear any proposed amendments. Unfortunately, I will out of town between the 1st and the 6th of March, so either first day, 26th of February, 2:30 p.m., I'm available. Another day will be the 9th of March, Monday, 10:45. I'm easy with both options. What's your view? I believe that if we seek an extension of the period of scrutiny up to the 25th of March, that means we have to report to the Housecom on the 13th of March. I don't know how many will come. If all the 18 district councils are to come, then it will be a big trouble. It is possible, Mr. Chairman. It's up to you to decide. I'm fine with either date. The 26th. I've checked my diary. It's okay for me. But for the 26th, well, if you count the days, there will be 10 days, but of course there are few public holidays in between. Of course, we can post the invitation on our website today. The 26th will be the first day. If not the 9th of March, that will be the second day. If there are too many deputations, we have to go back to the Housecom on the 13th. All right, Mr. Kwok suggests the 26th. Any questions? No? In the afternoon? Yes. 2:30 p.m. to 4:30. The only meeting is that we have a meeting of the Select Committee investigate into the XRL. I don't think any of us are on that committee. That's in relation to the delay of the XRL. So I think all the 10 of us would be able to make it. So let's fix it for the 26th. Okay, we can call it a day earlier today. Thank you.